Sir James Sunderland.
Mr Speaker, thank you very much. As a member of the Procedure Committee, this is of great interest to me, as it is to all members of the committee. And my position may not be completely beholden to that of the Chair, so I'll declare an interest straight away. For 3.5 years in this place, I've spent much of my time inadvertently comparing the two institutions in which I've served, both the MOD, the Army in particular, for 26 years, and since 2019 as an MP in this place. And they're quite different as institutions, and I'm just going to make a few comparisons which I think are useful to the debate. The first thing is, in the armed forces, a member of the armed forces who is accused of a crime, serious or otherwise, there's a presumption of innocence there, and that should be at the heart of this particular debate, as we've heard earlier. The MOD has a leave no man behind, a woman behind policy, and it's very important that for an individual who is charged or under investigation for a serious complaint, that they're not excommunicated. And the way that the MOD deals with that is often to manage it in-house, or, if necessary, to move the individual to another unit, so that that person can continue their responsibilities and duties elsewhere. It's important, of course, that they are not separated from the chain of command. Why? Because it's important the chain of command gives them the moral, the legal, the welfare support that they need. But it may well be that they're separated from those members of the unit that may be involved or made the accusation. So it's important that we manage this in the right way, and I think that that responsibility is important in the House. So can I first of all thank the leader and the shadow leader for the effort gone into the report so far on the Commission. I think we're 95% there, and I'm very happy with the recommendations as they stand. But I just want to draw attention to a couple of things that I think can be improved if I can. The important thing for me is that we've got a clear duty of care to all those in this place, no question about it. But that duty of care also exists towards the individual that may be accused of a particular offence. And it's that particular theme that I want to focus on if I can. Here in Westminster, I'll be quite honest, I've been appalled at times by the ease with which we hang colleagues out to dry. Again, not mentioning any names at all, but actually, when you come to this place, it's a big thing. You work hard to get here, reputations are important. And the way in which colleagues have been asked or voluntarily asked to leave the estate for what has been alleged is quite brutal. It's a brutal process, and I think that what we have to do is respect the fact that that colleague also might need some support. We are, of course, a team, whether it's Conservative Party, SNP, Lib Dems, Labour. We are also a team in this place, and I think we as members have a responsibility to each other, irrespective of the colour of your cloth. When the headlines hit, phones can go silent, colleagues are in the spotlight, they're vilified on social media, and they're on their own. And I think what we have to do also is to remember that we're all colleagues, and all of those that are not currently on the estate are also colleagues. So let's not forget that. And of course, reputations are also in tatters, and may be impossible to recover from that anyway, even if you are completely innocent of all of the charges. So I think that we can do better in this place, not just for the staff that are here, but also for the accused. For me, the basic tenet of this entire debate is that colleagues have to be innocent until proven guilty. Yes, we're MPs, yes, we have to maintain a certain bar, but it can't be the case that we are guilty until proven innocent. It has to be the case that we are innocent until proven guilty, and that must lie at the heart of how we take this forward as a House. So I think I want to just raise three core tenets for this process, if I may. The first one is the makeup and the scope of panels in this place has to be run by members. For me, it cannot be the case that members are subjugated by a panel, irrespective of what the job is we're trying to do, to staff panels. And therefore, this has to be managed and run by members for the benefit of members. When it comes to voting, it's up to this House to vote on which way we want to take it, not up to staff panels to do that on our behalf. The second point is that the point of assessment for exclusion cannot be proposed at any point in the justice process, and that's currently in the Commission's report. That must not be the case. And in my view, it needs to be dependent on a charge being brought. Just being accused of something, in my view, is not justification enough for separating a member from this place, innocent till proven guilty. So, in terms of what the report has said, if charged, were it considered that a member was dangerous to the public, then he or she would be held on remand and therefore unable to be present on the estate. To exclude a member who has not even been charged, whatever accusations might be made, would be a fundamental denial of the principle that people are innocent until guilt is properly determined. That came out loud and clear in the report for me, and again, I was at the heart of this. And criminal charge, in my view, is the right threshold, although I accept earlier there are difficulties with the point at which an arrest may be made and the time that it takes between the arrest and the charge. I don't have an answer for that particular issue, but please.
I thank the honourable gentleman for giving way. I wanted to make him aware that for a charge in criminal law, that means there is a high likelihood that a jury, reasonably instructed, would find the defendant guilty beyond all reasonable doubt. That is what a charge means in law. It is not, there is a case to answer, we'll see you in court. That is what it means. Does he not think that in something that is a civil process, which this is in this place, this is a workplace, it's a civil process, that setting the point at which we might act as a house at that point within the criminal process is just too high?
Mr Deputy Speaker, the Honourable Lady is not wrong, and I do concur with her point of view. But of course, it's entirely possible that when a charge is brought, that an individual may be found not guilty in a court of law. So actually, a charge does not itself define guilt. And therefore, by that same token, if you are arrested for a charge, I think that ultimately you've got to allow that process to play out until the point at which you are castigated, removed from the estate, voluntarily or otherwise. So I do take her point, but there's work to do for me by the Commission in drawing a distinction between the point at which you get arrested and the point at which a charge is made. Please.
I thank the honourable gentleman for giving way. He's just said that somebody can be charged but still be found not guilty in the same way that somebody could be arrested and not charged. It is about the evidence that is presented. And he said at the start we have a duty of care. Does he recognise, and we're talking about a risk-based exclusion process, it's not actually about the perpetrator alleged or otherwise, it's about the risk of the evidence presented at that time to those who remain. Can he say a little bit about what he proposes to do to tackle that risk if he waits until charge when based on the evidence that's presented to the House by the police at the moment?
Yeah, I thank the Honourable Lady for her intervention as well. And again, she's not wrong. I don't have an answer for you, but this is the key thing for me. Evidence itself is evidence that's used in a court of law. Are we judge and jury here? Is a staff panel judge and jury? Does the evidence that gets presented to a quango body of individuals here enough without a charge being brought to exclude the member from the estate? And I think that there's work to be done, as I said earlier, between the point of arrest and the point of a charge being brought. Please do.
I thank the honourable for giving way. By his logic, there is no evidence that could be presented by the police to this place of risk on which we could act. Is he really saying that? Or do we need a process that could assess the evidence being presented? Is he that specific about it that there is nothing that he could be told about the risk to people in this place posed by somebody that would cause him to act?
Mr Deputy Speaker, once again, I find myself concurring with a lot of what the lady is saying. But my particular view on this is that because we're debating it now, the answer isn't clear. And I think ultimately what we have to do is to allow the Commission to make further findings in respect of what the evidence does. My personal feeling is that actually we have to wait for the charge to be brought before we give enough credence to the evidence. Arrest, in my view, is not enough. But move on if I can. I think the second thing is that how do we manage as a House? How do we manage where complaints may be vexatious? We've discussed it earlier, but I'd like the Commission to do a bit more work on that. If a complaint has been made and it's entirely vexatious, we have to be able to spot that very early on and to deal with it. So, for example, another member in the consultation, quote, "I'm concerned about malicious complaints towards MPs, which are constantly on the rise, and members being excluded without it being a charge. Often these are politically motivated." If we take that logic through, it means basically that any member can be asked to leave the estate for any reason. Therefore, we have to get a process whereby there is credence given to an allegation, an arrest may or may not be made, and it's at the point at which the charge is brought, in my view, that gives that credence to the process. So we've got to make sure that we can properly define the gap that's in the middle. I think my further point is about management of risk, if I can. I'll intervene in a second. The important thing for this debate for me is about how we manage the risk-based exclusion. So that again is not clear from the Commission. So I want to basically understand better how we manage the risk. Who is responsible for managing that risk? Who's responsible for determining the evidence if it exists, and who's judge and jury? And how do we manage that risk? Who decides what factors? And this needs more work, in my view, before we can go firm on any vote or otherwise. Lastly, the proxy vote. Yes, in my view, a proxy vote has to happen. MPs are elected to do a job, and they must do that job until the point at which they're no longer able to do it. And again, innocent and proven guilty, there is a requirement for MPs to exercise their judgment and represent the interests of their constituents all throughout this process. And therefore, unlike the earlier recommendation from the Procedure Committee, I'm actually completely happy with the extension of the proxy vote in this particular case. MPs are still MPs, they're still part of a team, they still need support. They must not be left on the scrap heap either, and actually it's important for them, for their own peace of mind, for their own validation, to be able to exercise that vote via a proxy. And again, I'm not comfortable with the idea that those who've got a proxy vote are somehow published. I think those who have got a proxy vote shouldn't necessarily be identified as having a proxy vote for all the reasons of confidentiality that we've discussed before. And again, I also welcome the fact that the Commission is now actively considering extending the proxy vote scheme for other reasons. Currently, historically, it's been for maternity, paternity leave, but actually it should be extended beyond to illness and to those who may be excluded from the estate. Just to conclude, 3 points, if I may. Please.
At the moment, there is an issue as to whether or not people who have voluntarily excluded themselves from the estate because of allegations made against them, there's an issue as to whether or not those people should be able to exercise proxy votes. And I think the line has been taken that they shouldn't be able to exercise proxy votes because of the special circumstances surrounding their case. And it's then putting them on a par with people who are very ill or on maternity leave.
Mr. Speaker, thank you to the honourable member. My understanding is that proxy votes are part of this process. No doubt the leader will verify that in her summing up remarks, but it is entirely appropriate, as far as I'm concerned, if you're an MP, if you're elected, if you are elected to do a job, then you have to be able to do that if for reasons of force majeure or otherwise you can't be on the estate. And therefore I entirely support the notion that a proxy vote should be extended for all those with legitimate reasons not to be on the estate, and I welcome that further work from the Procedure Committee. I think the first point of conclusion is that exclusion should absolutely be a last resort, and I think we've agreed that this afternoon. And actually, exclusion should also be, ideally, at the behest of the individual. And I totally agree there's unique circumstances, and that what we're discussing here is in the unlikely event that a member might not voluntarily exclude him or herself from the estate. I think the second thing is that I am absolutely clear as an individual, as a member, that both the Procedure Committee and the Committee on Standards have suggested that the final decision to exclude could or should be put to the House. I'm afraid that is entirely right. It's up to us as members to make the finding in this particular case. It is up to us as members to vote. I think also that...
On that point,
please.
I'm grateful. If it's put to the House on a vote, how will confidentiality be retained?
It's another element, if I may, of what the Commission and the shadow leader have to work through, because ultimately I think it's up to us as members to make that finding on behalf of fellow members. It can't be made for us by a sub-panel or a committee, and therefore this is a further bit of work that the committee has to go through. My final point is this, and it's an obvious point to make. Should a member be found guilty of a relevant offence, they would most likely receive a custodial sentence or otherwise, and be subject to the Record of MPs Act 2015. That is the point at which we are likely not to become MPs, and I think that until that point happens in time, due respect and credence should be given to all of us as MPs. A duty of care should be given also. So finally, Mr. Speaker, members should be careful, in my view, what they wish for. This is a difficult debate. There's work to be done, in my view. So let's not ignore, please, both the duty of care that we have towards staff in this place, but also the duty of care to each other. Thank you.
Sir Chris Bryan.
Thank you, Sir Roger. It's a delight to